Your divorce is final, but life doesn't stop changing. What if you lose your job? Your kids need a shift in parenting time. Your ex isn't following the order. Or you found out hidden information, new information. Can you go back to court and modify the divorce judgment? Or are you stuck with it forever? Let's look at when you can, how you can, and why you should modify a divorce judgment in Michigan. I'm Jim Kraayeveld, founding attorney at Kraayeveld Family Law here in Grand Rapids, Michigan. Typically, a divorce judgment is final. It's a judgment. But that's not always set in stone. Michigan law allows some provisions of a judgment to be changed, but some of them can't be, and some of them can be under certain circumstances. Let's dive into the different parts of a judgment and what can or can't be changed. What can be modified? Custody, parenting time, child support are always modifiable when the circumstances change or there's proper cause. So, in Michigan, you have to have a material change in circumstances or proper cause to seek a change in child custody or parenting time. Yes, a parent is convicted for drunk driving a third time and they had the kids in the car with them. That's going to be a proper cause or a big change in circumstances. A parent loses their job, ends up in jail or prison. Well, there's a big change or proper cause. And so custody and parenting time can always be modified. It needs something big. Parenting time even can have changes, and those don't need to be nearly as drastic. For example, school times change by 30 or 60 minutes. You may need to change the start and ending time of parenting time. Child support can change. Yes, a parent's income goes up or down. They get a new job, so you can modify child support. Under Michigan law, you can modify child support every 3 years, even if you don't know of any changes. They'll do a review to see where things should be at. You can automatically get those through the front of the court. But yes, any kind of a change with health insurance coverage, change in employment can all affect how much child support should be ordered and paid. I want to at least remind everybody, you don't get a retroactive change in Michigan. So if there is a change in circumstances and you want to modify child support one way or the other, up or down, you need to file a motion to get the process going. Proper cause. There's an old case from, I want to say 20, 30 years ago, Vodvarka. It dealt with, the parent had 1 or 2 drunk drivings prior to the judgment. Normally you need to have a big change post-judgment to be able to come back to court. But there was another drunk driving. And if you have enough of them combined, you've got proper cause. Alimony. We're going to move into what may or may not be modifiable. Sometimes you can modify alimony, spousal support, if the judgment allows for it. So again, if you have a change in job, you have a change in financial needs, the other party gets married and has everything taken care of, those are things that you can bring to the court. But some judgments and the parties reach agreements in consent judgments where they say spousal support is not going to be modifiable. So they may just simply have an agreement. We agree to pay a set amount for a set period of time, regardless of what happens. Some judgments include an alimony in gross provision, which is different than your regular spousal support. Alimony in gross is more of a property distribution that says, I'm going to pay you a set amount of money, whether over time, but it's a set amount. That is typically also not going to be modified. Income changes, remarriage, any of those things, health conditions, you end up where you're unable to work, are all reasons to modify spousal support unless you agree to a non-modifiable. Lastly, property division is typically, without an exception, never modifiable. When you settle your property division, your division of assets and division of debts, that's typically going to remain in place no matter what. Exceptions to that, cases of fraud or someone hid assets and lied during discovery or lied during the case. Judges are typically very reluctant to open up any kind of a judgment to deal with property issues. Fraud, yes, as you got lied to. I didn't disclose a Bitcoin account, a cryptocurrency account. They had real estate that they owned, but it was in someone else's name, and they used a straw man to hide that from you. If there's a mistake, for example, someone says, oops, we forgot to add a zero. It should have been $100,000 for the IRA, not $10,000. You can fix mistakes, but you're going to have to prove that it was a mistake that was made, and it's typically it's called a scrivener's error. It's a typing mistake. What isn't a mistake that you can fix is, oops, I made a mistake in settling. That's called regret. I shouldn't have settled for this. I shouldn't have agreed to that. Well, that's not a mistake that the court can fix. That's you having regrets, and that isn't going to be modifiable. Now, again, a little exception to issues of property that can be modified. For example, you agree to a particular realtor. They can't get the house sold. One party says, I think the house should be listed at $800,000. One says, no, it should be listed at $550,000. There's a substantial dispute. You can go back to court and get the court's help and say, I need a particular realtor. I need a new one. We need to list it for a particular price. And you'll have a hearing on that. And you can have a court enforce what the parties intended. So, in sum, if you're thinking that you need to have a modification, custody, child support, spousal support, or even a property enforcement issue, consult an attorney. But if you can't prove fraud, mistake, or change in circumstances, the court might rule that your motion is frivolous. And frivolous motions are subject to sanctions. So, make sure that you have a proper basis when you file that motion with the court. You'll again file that motion with the same court that entered the divorce judgment, because that's the court that can enforce the terms or modify them. So, custody and parenting time, show your change in circumstances or proper cause. If it's a property division issue, provide evidence of fraud or mistake. Again, as everybody's aware, if you have to seek a modification, that means more litigation, which means more attorney's fees, more stress. But if you have the strong evidence, you can file your motion. But if you don't, you may not want to file the motion because you could get assessed with court costs and attorney's fees for the other side. A little caveat that I want to throw out there, you may raise one issue, but the other side may counter-raise other issues, and judges will review all the related issues, not just the one that you raise. So, divorce orders are supposed to be final, but they're not always necessarily permanent. Custody support and spousal support sometimes can be changed. Property usually can't. And even though your life has changed since your divorce, you're going to need to consult with an attorney to see whether or not modification is allowed, or if it's possible, or if it's even pragmatic, a wise thing to do. Until next time.